Let me come to the policy positions. I'll say a bit about the UK position in detail, as I'll tell you a bit about the Scottish Government's white paper. The Welsh Government, I won't be talking much about what they want to do, but let me just tell you, securing Wales's future is essentially about wanting full and unfettered access to the single market for goods, services and capital. They also care about structural funds and social and environmental protections. And they do care particularly about some sectors like agricultural and food products. So that's the Welsh Government position. Northern Ireland, as I said, has experienced a political crisis, so there is no single government position there, of course, because there isn't a government at the moment. There's still a negotiation post the election. The key issue for Northern Ireland is, as I said, the maintenance of the Good Friday agreements. And let's not forget there's a lot of funding that has also gone on the back of those agreements. There's a Peace 4 flow of funds at the moment, which earmarks some 270 million euros until 2020. These are important structural interventions that have helped both sides of Northern Ireland and the Irish Republic. I would suggest to you that, again, if you look at the performance of David Davis in the exiting the EU Select Committee, and if you like horror movies, it's a very good watch. He basically, when interrogated by Maria Caulfield MP, made it very clear there are no solutions yet to the problem of how one could avoid a customs border between the North and the rest of Ireland. That's quite clear in his answers. They're working on it, he said. They're looking at the trusted trader scheme. They're looking at the possibility of having more electronic systems to ensure they don't do the checks on the border. Of course, as I'll come back, if you have those sorts of systems, actually it could help what the Scottish Government is proposing as well. But I'll come back to that. This slide sets out the UK Government's white paper. A lot of you will be familiar with the plan. The 12-point plan. I won't go through all of the points. I will focus on the two in a moment. There are positive notes in there, and I think these are obviously attempts to try and get a good negotiation. Smooth transition and new arrangements, we'll come back to that. Cooperation in fighting crime and terrorism, one of the strong cards, if you hear people like Charles Grant, who also sits on the Standing Council, these are the strong cards that the UK has to play. These are the areas where our cooperation is valued by the EU. I'll talk a bit about the main issue, which is the main red lines, which have forced the UK to go down a particular hard Brexit route. The Great Repeal Bill, a bit of a misnomer. It's a Great Consolidation Bill, which is essentially bringing the whole body of EU law as it is at the moment of Brexit into the whole acquis communautaire into UK legislation, which means that there isn't a break point. But the real strategic issue, as you will see, is what happens after that. That's fine at time t equals 0. What happens after that? And that's the key issue. The real issue for the UK government, the reason why they decided not to go for European single market membership, is because they realized that the EU would not accept the political red lines that the UK government has set. Particularly, they want to control immigration, they want to take control on immigration, and that cuts across the freedom of movement, which the EU sees as an integral part of membership of the single market. And the other is moving outside the jurisdiction of the Court of Justice of the European Union. No foreign judges. No foreign judges, I was told, I didn't realize until recently, was a Swiss expression, but we seem to have adopted it. And this implied rejecting membership of the European single market. I think it's a pity, in my view. There's a very interesting lecture given at Edinburgh University by the president of the EFTA Court, Karl Baudenbacher, in which he pointed out some interesting facts, which I think commentators like myself and others thought might have offered some way out to the UK government's position that they don't want the Court of Justice of the European Union to be, if you like, to have this lead role in regulating the European single market. To be clear, the EU's position on this is actually quite consistent. If you have a single market, you have to have a single body controlling its regulation. And yet, the way in which this works for those countries that are not members of the EU but are part of EFTA, of the European Free Trade Association, and are part of the single market, Iceland, Norway, Liechtenstein, is that they have an equivalent pillar. They work across the with the EFTA court and the EFTA surveillance unit. And it acts almost like a proxy for the Court of Justice of the European Union. But these are the key points. The EFTA court doesn't have primacy. And I thought as a point of principle that would have been quite important to the UK government, because if the EFTA court rules, then there's no requirement, there's no immediate change in UK legislation. There is a requirement for the EU, there would be a requirement as there is for the EFTA EEA countries to adapt, but there isn't an immediate requirement. There's no primacy. These effects only take place after the implementation of a legal act in the domestic legal order. There are no penalty payments resulting from infringement, unlike infringements within the EU of the Court of Justice of the European Union. And the EFTA court is an independent court of law. It is not a supranational covering 27 countries. And I think one thing that has to be remembered, and this will play an important part in regulation, we would like a bilateral deal. If you read the white paper, it talks about some dispute resolution mechanism as yet undefined. It talks about what's in the Canada-Europe trade agreement. It talks about Switzerland to some extent. It talks about actually, I think, the New Zealand-Korea deal. It talks about some sort of dispute and arbitration mechanism. But actually, the EU Council has made it very clear they don't like the current arrangement that Switzerland has. Switzerland has about 120 treaties with the EU, and they are static treaties. They do not adapt as the body of law of the EU evolves. The EU doesn't like that, and as a result, they've actually pretty much told Switzerland that they would like them to adapt. And since 2008, they're saying to Switzerland, no more agreements, and they are urging the Swiss to move to the EEA arrangement. And indeed, the position at the moment is that you cannot have, of the EU, you cannot have access to the full unfettered access to the European single market unless you have some surveillance mechanism and some independent court. And that is, I think, the sticking point. Okay? So what the UK wants is some sui generis, bespoke type of relationship. It actually is quite ironic. I've actually heard that expression sui generis in a panel I was on from a representative of the UK government. And I thought it was quite interesting because actually it's exactly what the Scottish government is seeking through its white paper. It's some attempt to find a solution which is bespoke. And as I say, Europe is generally looking for able to look at bespoke solutions, although this particular one is going in the wrong direction. I think a key issue for the UK as it develops this bespoke relationship, even if it manages to persuade the EU to shift from its current red lines, is that what will this bespoke model look like and how will it adapt to the fact that EU regulation will continue to evolve over time? The key question is this: what is the UK's trade strategy? Are we still going to be orienting ourselves to Europe because of gravity effects? Because if we are, then having the Great Repeal Bill and freezing our incorporation of the acquis at one point in time doesn't help us, because EU regulations will begin to diverge. It'll make it more difficult for us to adapt, especially if this dispute resolution mechanism, so this dispute resolution mechanism, whatever it is, will actually struggle with that. So what is our EU strategy? I actually think there was a really good session with the Europe and External Relations Committee by Sir David Edward recently at Holyrood. And I'll quote a couple of bits of his testimony because I think it's really important. If Europe remains our major market, and it's 45% of our market, and it's not going to decline a lot, and indeed, if we want to grow that relationship, we cannot deviate from EU legislation. I'll just quote one point which Sir David Edward made. I would put it like this. He said, "You might escape the direct jurisdiction of the Court of Justice, but you will not escape the jurisprudence of the Court of Justice." The Court of Justice case law is still there. And if we want to export to these markets, we can't ignore what they're doing. If EU regulations begin to evolve, what are we going to do? And look at what Switzerland does. Because in another session with the Europe and External Relations Committee, Professor Usch of the University of Zurich told the committee that while Switzerland and the EU had this bilateral relationship, actually what Switzerland has done over time, even despite the fact that it isn't a member of the EU or the EEA, it has autonomously adopted EU law into its own statutes since the late 80s. It's had to do that, otherwise it couldn't trade with the EU. he estimates that 30 to 50% of all the acts and ordinances at the federal level in Switzerland are influenced by EU law, directly or indirectly. So this comes back to the regulation point I made earlier. If you want to just walk away from Europe, you can do so. But if you want to trade with Europe, you can't walk away. They're still there. The Court of Justice will be evolving its judgment. You'll have to adapt your regulations. If you don't, then you'll have to struggle to export markets which are not Europe. And of course, there's been also interesting examples given recently in the press about what happens if we reach a new free trade agreement with America, with the United States of America, which will have as one of its key propositions, no doubt, because the US is very keen to export in agricultural terms, and they find the EU a bit of a barrier because of its food standards. They'll want to export certain types of foods to the UK. And at the moment, they can't because the EU has taken quite a different line in maintaining certain standards. But if we give in because we have a weak bargaining position and we start importing chlorinated chicken carcasses or hormone-grown beef, and that's fine, we can do that. But if we then want to, that goes into our food chain, that will have an impact on our ability to export into Europe. So there's a number of issues here which are really important. We can run away from Europe, but actually there's some real issues. The Swiss laws, as I say, shadow the EU. Sectoral deals are also a problem for the WTO. You've seen in the white paper, the UK is really keen to do a deal in certain sectors. There are rules in the WTO, Article 24 of the GATT, which prevents you from doing that. You cannot go for sectoral deals. If it's going to be a free trade agreement, it has to be comprehensive for it to pass the rules of the WTO. I'll mention the red lines. Let me come to the Standing Council. This is just setting out how the Standing Council works, what our function is. I won't really go into the details of this. Essentially, we have three principal functions, which is to provide expert advice on securing our relationship. We meet to consider the impact of any proposed changes to the UK's relationship to the EU on Scottish interests and to advise Scottish ministers through negotiations in order to secure Scottish interests and objectives. We've tended to meet on a 6 to 8 week timetable in plenary. We've also had work streams up to now. An important point, which is because occasionally I get asked, it must have been difficult for you to write Scotland's place in Europe, and I have to keep saying we haven't written Scotland's place in Europe. It's very much a Scottish Government white paper, and that's a really important distinction. We are an advisory group. Clearly, we have provided advice at different points, but actually, the white paper is the government's policy position, and I think that's an important point. So let me tell you a bit about Scotland's place in Europe, because it's a really interesting. I think it's as John Kerr, who gave a Policy Scotland lecture, said, it's a technically really impressive document. It's trying to achieve something which is very, very difficult in a situation where Scotland hasn't chosen to leave the EU. But let me tell you a couple of points, because it's really important. Some of these points have been misunderstood in the press, particularly. First, the key proposition is that its argument is that the whole of the UK should stay within the European single market. That's the best possible scenario. It's not, of course, what Scotland voted for. It's not what the Scottish Government wants. It would like to stay in the EU, but it was prepared to compromise in this document in saying we're prepared to keep the whole of the EU in the European single market. And indeed, by the way, also the customs union. The argument was the UK should stay in the customs union. And both of these points, as we know from the UK white paper, have not been accepted. Second, the proposition is that failing that, we should try and the UK should try and develop a differentiated solution with the EU, which allows Scotland to remain within the European single market. Let me take the final point first, just to be absolutely clear, and I think this is very clear in the paper. The paper makes it very clear that this would need to be agreed by the UK as the member state. There was no proposition to the EU. This was very clearly put to the UK as a solution. The other point to make, and this is really important, it's a parallel market solution. I've read numerous times since the publication of this white paper the proposition that this is about putting barriers in the trade between Scotland and England and Wales, and that's nonsense. It's a parallel market solution. There would be no barriers in intra-UK movement of goods and services. The only issues would arise in terms of channeling goods from England, say, to Scotland, to the EU, or vice versa. Goods produced in Bristol, which were destined to Glasgow, solely to Glasgow, would not be totally unaffected by the solution that's proposed here. Goods produced in Edinburgh that would go to Cardiff would be totally unaffected. Scotland would have 1 foot within the existing UK commercial product markets and 1 foot within the European single market. Yes, it's a challenging solution because it relies on a lot of the issues that I was mentioning earlier with respect to Northern Ireland. How do you conduct checks without having doing those at the border? But there are systems to do that. We know there exist systems for that within the EU at the moment. And indeed, the main issue, if there is an issue, is, and I was asked this point by the Holyrood Committee, Europe and External Relations Committee, is how do you make this work in terms of this differential system on goods if there is a divergence of product market regulations between Scotland and the rest of the UK? And there are 2 answers to that. It's not in Scotland's place in Europe, but I think there are structures that you can develop to do that. First, as we've seen, the UK will need in some way to shadow European single market. There's no way in which you could simply walk away from it. Scotland being part of the European single market may be a useful mechanism, I've used this expression, to tether part of the UK to the European single market. The second answer to this probably lies in imagining a UK Federal Competition and Markets Authority whose role is first of all to advise the UK Parliament to shadow EEA regulations, single market regulations, to ensure that UK legislation and regulations don't stray too far from the EU, and second, perhaps could act as a surveillance authority for a differentiated Scottish participation in the European single market. And third, perhaps act as a liaison with the EFTA Court or the Court of Justice of the European Union. And then you can begin to see perhaps a solution to how this would be adapted. There are other challenges in Scotland's place in Europe. They're to do with the fact that membership of the EFTA or EEA areas at the moment is restricted to nation states. Those treaties would need to be changed, but there's a lot of treaties that are having to be changed anyway as a result of Brexit. The other big area that SPY mentions is it's around the repatriation of competences. And there are a number of, it outlines a number of powers no longer subject to EU law, which would need to be repatriated to Scotland: agriculture, fisheries, education, health, justice, environmental protections. Repatriated competences in reserved areas where Scotland has expressed a view that it wants to do more to protect citizens' rights, so these might want to be devolved. It's a matter of negotiation. And then there's the issue that if you want to have a differentiated solution, there's a number of other areas where you would have to grant the Scottish Parliament additional powers. And indeed, I think an important point in all of this is that Brexit, and 2 colleagues at Glasgow have recently, Noreen Burrows and Maria Fletcher, have recently published an article in the Juridical Review, I think it's about to come out, which is entitled "Brexit as a Constitutional Shock and its Threat to the Devolution Settlement." The point is this, and I think the Prime Minister actually made this point when she spoke on the 3rd of March in a speech. She recognised that I'm afraid the status quo is just likely to be threatened by Brexit, because immediately you have these issues that you have to confront. And there are issues in terms of how the market operates within the UK that you're going to have to confront. And Noreen and Maria actually in that paper highlight a number of areas where there is essentially Brexit is going to cause some change in that area anyway. So it's hugely important. The other point to make about SPY is that there is variable geometry in Europe. 2 colleagues in the Standing Council, David Martin, MEP, and Alan Smith, MEP, have produced a different diagram, a bit like this. It also has outermost regions and other parts of various dominions and overseas territories for the EU 28. And it shows you just how complicated the European map is. And it's not impossible to think that you might want to deploy some of this variable geometry. And this is one of the points that SPY makes.